support that claim. We didn't raise this CUTPA claim, they did. And we think that these videos support our defense, and they're, with respect to 45.
So you're back to now the Megyn Kelly video that I already ruled on?
Absolutely. And we'd ask you to reconsider, because we think on the law of this case, I don't want to try the case again. So they've solicited testimony about his reaction to the video. They've called him a liar any number of times. We had a scorecard going in the case before we ruled that the law of the case was that he lied. It was up to 80, 90 times.
So Ms. Paz testified as to his reaction to the video, yes?
Yes.
And what did she say?
I'll refer to my notes. Not happy with how the interview was reflected him in Sandy Hook. Then there was a claim that Mr. Jones showed only part of an interview with Mr. Heslin, that somehow that they had manipulated this video to serve their own purposes. And I want the jury to see what was on Megyn Kelly, and I want the jury to draw its own inferences, not argumentative inferences, about whether in fact Mr. Jones misrepresented anything. And I think the Megyn Kelly interview is 17 minutes. The other one I reviewed, by the way, I was wrong about the 50. It's about 19 minutes. These are both squarely within what has been presented by the plaintiffs. And what's more, Judge,
So you're offering like the Megyn Kelly interview to
completeness
to show that he was right to be unhappy?
To show several things. That there was more we didn't introduce the 16 metrics in this case, they did. And here was a widely broadcast interview that was wildly controversial, that is replete with Trump's support of him. And I would say that there were many reasons to be just unhappy for the clicks to increase in 2016. And that's one of them. And what's more,
well, she testified that he was unhappy, and you wanted in
and that there were misrepresentations about it.
Misrepresentations in the video.
Right.
Okay, but the free speech system's her testimony was that he was unhappy.
Judge, look, here's what I got to say about this. I'll make, if the court persists in the ruling, I'll make a motion, which I'm sure will be denied for a mistrial, and here's the reason for it. I've marked as a court exhibit, I think it's 671, an opening statement that I gave today, or I didn't know if I'd be able to give in the course of this case. And it was clear to me that exaggeration and motive was our defense. I didn't know that I'd get to give it, so I printed it out so that if you stopped me, I could mark it for identification. But my view is that the door was opened, and then I was lulled into believing that we were going to be able to try these issues when the plaintiffs who objected to every single exhibit that I offered several hundred exhibits themselves that contained this material. How can this not be? And so any claim that it's hearsay, any claim that it's that there's some sort of evidentiary foundation has been waived by the offer. What I'm trying to do is defend Alex Jones and his contention. The contention I told the jury, he's an angry populist who, as Mr. Maddy has said to several witnesses, believes there's a global conspiracy to enslave people. It may not be a belief you or I share, but you can't use a CUTPA statute to silence a person for unpopular speech, and that's what they're trying to do here. And I'm pretty confident on my odds in the appellate court, but the odds then will be a retrial. We want to try this case once. That's the reason that we stipulated to withdrawal of the stay in free speech systems in the bankruptcy matter, so that we wouldn't have successive trials. We didn't want Jones to have to go to trial in free speech. We just want this jury right now to decide the issues that the plaintiffs framed. And we think that this material is clearly responsive and within the scope of their case.
All right, Attorney Maddy.
Your Honor, am I arguing on the motion for reconsideration, your motion for reconsideration here? Okay, well, it's okay. Let me say what I think I heard. What I think I heard was Attorney Pattis started talking about 222, which is the 2016 social media metrics. And I think what he was saying was the new reason he's offering the court for why the Megyn Kelly video is relevant is because it suggests that whatever bump in social media traffic may have occurred in 2016 is due to Trump. And if that's the case, it's hearsay. Because if there's some sort of out-of-court statement suggesting that Mr. Jones's new popularity in 2016 was due to Trump, that is hearsay. It cannot come in for that. They're offering an out-of-court video for the truth of that matter. So that's what I heard him arguing on the motion for reconsideration. I didn't hear anything new in the argument about why Mr. Jones's statements, out-of-court statements about Cindy Hook should be admitted now. What we know he said in that video was essentially he was mischaracterizing what he had previously said. Things like, I didn't say that, or I didn't say that. Also hearsay statements that are being offered to this jury to show them Mr. Jones never said these things. Not only is it hearsay, but it also offends the default ruling that the court has made. So nothing I've heard suggests that anything about this video is admissible under the rules of evidence.
But Judge, they waived the hearsay objection by offering. I mean, how do you offer an exhibit and then
offer the video?
Oh, the Megyn Kelly thing, but I'm
talking about Megyn Kelly.
How do you, how do you offer something and then claim it's hearsay? How does that work?
Your Honor,
for a fair trial.
I'm sorry. I understood 45 was withdrawn so that people could review it to assess.
And I'm reviewing that motion to address it on a seriatim basis, but as to 40, we say rule of completeness, Judge.
All right. So I am going to deny the motion. And we can get the jury.
Well, we still have the other exhibit, Judge. I mean, if you're not going to permit all as to 45, I
thought I ruled on one before lunch, and I just ruled on the Megyn Kelly one.
I thought you were going to look at 45 at lunch. That was the shorter one. Did I miss that?
I looked at the Megyn Kelly one. I ruled on the other one before lunch. And then there was a third one, but then you didn't pursue it. So during this, and the rulings during the cross-examination of this witness.
So no part of 40, which has previously been admitted, can be gone over with attorney costs?
I did. You offered it in its entirety, and that there was.
Just for the record, Your Honor, Exhibit 40 is not a full exhibit.
45, excuse me.
That's the Megyn Kelly. 45 is the one that is admitted, and you had talked before break. You had said if they wanted to look at it over recess, they find certain parts.
But I'm not right. So I before lunch sustained the objection on the entirety of the 50-minute video. I haven't changed the ruling, and this is now, of course, we're talking about during your examination of Ms. Paz.
And the basis of the ruling, Judge, just so I understand it for the record, it can't be hearsay because it's in full exhibit.
I think we're ready for the jury.
My record needs to be complete, Judge. The basis for upholding that objection is?
We're ready for the jury.
That's not a legal basis, Judge. May I have a ruling that the appellate court can understand?
There was an objection, and I sustained the objection.
But there was no legal basis stated. I'm entitled to that under the practice book, and you should deny the motion on that grounds alone. It's insufficient for somebody to stand up. They're supposed to provide me with notice so that I can respond.
I believe that he argued it for 20 minutes, and I think the record is clear, Attorney Pattis.
He said hearsay, but it can't be.
And if it's not clear, wouldn't be the first time, and you'll move for an articulation, and I'll articulate when I'm directed to by the appellate court. I understand that there will be an appeal. I assume
maybe
there
not.
will be.
We might win.
There may be an appeal. There may not be an appeal then, but I assume there will be an appeal.
May I just make one comment, Your Honor?
I suppose so. I just hate to keep this jury waiting because they're so prompt.
Just very quickly, the objection we made to 45 was on scope grounds among other things, and that's what the purpose of the recess was to
Right,
review.
and I said 3 times that for the purposes of this witness, during this examination, the objections are sustained. I don't know how many more times I have to say it, right?
No more, Judge. I got it.
I did just want to add, obviously Attorney Pattis is free to use Exhibit 222 with Ms. Paz, but I just wanted to renew my concern about offering any sort of hearsay testimony about